In this video, we're going to be talking about situations where property passes to a third party and how we can use equitable tracing to trace into that property. Now, in the previous video, we were looking at equitable tracing in a context where the property remains with the trustee, such as where the property has been mixed with other property. So this is a second situation, and it considers the situation in which trust property is misapplied in such a way that it is mixed with property belonging to an innocent third party. Therefore, rather than consider the issue which rose in the previous video concerning the obligations of the wrongdoing trustee, it is now necessary to essentially decide how property belonging to an innocent third party should be allocated between them. Now, it was held in Re Diplock from 1948 that the entitlement of the beneficiary to the mixed fund should rank pari passu, or in equal step or proportionately, with the rights of the innocent volunteer. Note, an innocent volunteer is distinct from a purchaser for value without notice. So let's have a look at this now. So third party has knowledge or notice. If the third party that the property has passed in breach of trust, they are subject to the same liability. So if they know that the property has been passed to them in breach of trust, they are subject to the same liability, personal and proprietary, as the original fiduciary by the doctrine of knowing receipt. A party with notice of the trust cannot raise the defence of being a bona fide purchaser for value without notice. So this is, as you should know by now, equity's darling, and may have to restore the property even if they have provided value. So in other words, even if they have actually bought it. So if you buy the trust property and have notice of it being trust property, then you may have to restore that trust property to the beneficiary. So we have this case here, and in this case, the partner of an art collector sold Art Deco furniture after his death, realizing $15 million. Now, $10 million was deposited with the Crédit Agricole Bank, and the art collector's family succeeded in establishing that the furniture belonged to the collector's father and mother rather than the collector, and that they were entitled to trace the property. So Mr. Sims was the partner for many years of Christo Michaelidis, whose parents had built up a collection of Art Deco furniture, which we're just going to call the collection, okay? Now, on the death of Mr. Michaelidis, and unknown to his family, Mr. Sims sold this collection for $15 million in the spring of 2000. Now, $10 million was deposited with the Crédit Agricole Bank, and the art collector's family succeeded in establishing that the furniture belonged to the collector's father and mother, rather than the collector himself, and that they were entitled to trace that property. Okay, so they could trace the property itself into the hands of the bank and claim it. So in this case, the Gibraltar Court of Appeal held that the bank had notice of the claimant's proprietary interest in the money deposited and could not therefore claim the defence of being a bona fide purchaser for value without notice. So because the bank had noticed that, they had to pay the money back to the family, they didn't necessarily have knowledge, but they did have notice, and because of this, they couldn't claim the defence of being a bona fide purchaser for value without notice. They couldn't claim the defence of being equity's darling. And the Privy Council dismissed an appeal by the bank too. Okay, so this is showing a situation, where we have third party has knowledge or notice. If, the third party knows that the property passed in breach of trust, they are subject to the same liability as the original fiduciary, okay, as we just mentioned. Okay, innocent volunteers. So in contrast, an innocent volunteer is one who is not party to and does not have notice of the breach of trust, okay? and who has not provided value for the property received. So, in other words, an innocent person, innocent meaning they have no knowledge of the breach of trust, and volunteer meaning that they have not provided any value. Okay, so that's the sort of definition of an innocent volunteer. And from Foskett and McKeown from 2001, a trustee took money from the trust and used it to pay the premiums on an insurance policy which was made in favour of his children. Now, it was held that the beneficiaries under the trust were entitled to trace in equity into the proceeds of the insurance policy after the trustee's death. So in this case, a trustee had been misusing the trust funds to pay 2 of the 5 premiums on a life assurance policy of about £20,000, which he had taken out in favour of his wife and children. Now, when the trustee committed suicide and the breach of trust was discovered, it was held that the beneficiaries of the trust were entitled to trace into the monies paid out under the life assurance policy on the basis that their money had been mixed with the trustee's own money to pay for the life assurance policy premiums, okay, which were to pay a lump sum to the trustee's children on the trustee's death. Now, the proportion of the proceeds attributable to the misappropriated money was traced. The children kept the proceeds attributable to the trustee's own money. So whereas the Court of Appeal had held that the beneficiaries were entitled only to an amount of money equal to 2 premiums, in other words, about £20,000, which he had paid for 2 out of the 5 premiums, the House of Lords held that they were entitled to 2/5 of the lump sum, which was worth about £400,000. So, prima facie, an innocent volunteer receives property in breach of trust. If they receive that property in breach of trust, they have to give it back because it's not theirs. But if they have mixed it with their own property, then they can claim proportionally their own money back from the mixed funds. Whereas a trustee in breach or a third party with knowledge or notice cannot claim their own money back from the mixed fund. Okay, and so in re Diplock, this is Diplock and Wintle from 1948, in this case, the trust failed as a purpose trust, so the property was held on a resulting trust for the residuary beneficiaries. Now, accordingly, they were entitled to trace the money from the innocent parties, including some charities. And Lord Green said that this is so follows, we think, from the analysis we have made of the principle itself, namely that when once the proprietary interest has been created by equity as a result of the wrongful or unauthorised dealing by the original recipient of the money, that interest will persist and be operative against an innocent third party who is a volunteer, provided only that means of identification or disentanglement remain. For such purpose, it cannot make any difference whether the mixing was done by the original recipient, sometimes called the fiduciary agent, or by the innocent third party. So as long as you can identify the property in the hands of the innocent volunteer, you can trace it. Lord Green continues, where an innocent volunteer, as distinct from a purchaser for value without notice, who would have a full defence, mixes money of his own with money which in equity belongs to another person, or is found in possession of such a mixture, although that other person cannot claim a charge on the mass superior to the claim of the volunteer, he is entitled nevertheless to a charge ranking pari passu with the claim of the volunteer. Okay, so the innocent volunteer and the beneficiary have equal pari passu mixed claims to a mixed trust. They have proportionate claims to the fund. And we talked a little bit about pari passu in the previous video, but if you do have particular questions or concerns about that, then do leave a comment below. In the case, however, of a volunteer who takes without notice, for example by way of gift from the fiduciary agent, if there is no question of mixing, he holds the money on behalf of the true owner whose equitable rights to the money still persist as against him. On the other hand, if the volunteer mixes the money with money of his own or receives it mixed from the fiduciary agent, he must admit the claim of the true owner, but is not precluded from setting up his own claim in respect of the monies of his own which have been contributed to the mixed fund. So if the money is not mixed, the beneficiary can take it back, but if the money is mixed, then they will share it pari passu. Okay, as I said, proportionate claims of equal ranking. The result is that they share pari passu. It would be inequitable for the volunteer to claim priority for the reason that he is a volunteer. It would be equally inequitable for the true owner of the money to claim priority over the volunteer for the reason that the volunteer is innocent and cannot be said to act unconscionably if he claims equal treatment for himself. The mutual recognition of one another's rights is what equity insists upon as a condition of giving relief. Okay, so in summary, for innocent volunteers then, if the funds are easily identifiable, the volunteer has to give them back. Okay, if they are mixed, then they will share it pari passu. That's really the summary of what's been said in this video. Now, again, this whole concept of equitable tracing can cause a lot of people to trip up, especially when it comes to the distribution of property, talking about rolling charges and pari passu, etc., etc. So if you do have any questions about this video or the whole concept of equitable tracing from the very beginning, then please do leave any questions you have below, because I'm more than happy to help out where I can. Okay, if you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.